Good morning, everyone. I hope everyone is well. Thank you so much for being with us this weekend. I would encourage everyone to introduce themselves in the chat. Please include your name, your location, the name of your podcast. And we'll give everybody a couple of minutes to continue to stream in and look forward to seeing you in the chat.
Am I starting now, Erica?
We'll just give folks a couple more minutes to stream in.
Got it. Okay. Hi, everyone. Happy Saturday.
And while we're making acquaintances in the chat, I want to take the opportunity to introduce our very, very, very special guest for this morning's session, Ms. Merlin Jean-Louis, who is an incredible attorney. She has her own law firm. Super amazing woman, and I'll stop there. I'll let her continue to speak to who she is and the incredible wealth of knowledge she's going to share with us over the next hour.
Thanks, Erica.
Hey, Jimmy at Punks Under Pressure podcast. I am just going to ask everyone to centralize the conversation in the chat in the Hoover app, please. And Ms. Jean-Louis, we are ready whenever you are.
Okay, let's get this started. Good morning, everyone. Thank you so much for taking time out of your day to attend this presentation. This is the first presentation of the second annual Afros and Audio Festival. It had to be done virtually, and I can definitely speak on behalf of Talib, Latrice, and the whole Afros Audio team for thanking you for being here. We really appreciate it. I'm gonna get into this presentation. It's gonna be as interactive as possible, given the circumstances, but I hope you are able to get a lot of information and have some fun at the same time. I know people think that the law is could be a little bit intimidating, but I'm gonna try and make it a little bit fun. So let's get into this. And I could love to see your faces too. If you want to show yourself, I know it's morning time. I mean, it's 10 a.m. here. I don't know if you're in California right now. So if I could see you, that'd be great. Thank you. Hey, everyone. Okay, let's do this. Let me share my screen and get this started. Okay. So this presentation is going to be called Mind Your Podcast. Basically, we're going to be talking about legal and business issues facing podcasters. Again, my name is Merlin Jean-Louis, and who am I? I am the founder of Jean-Louis Law. It's a business entertainment law firm based out in New York City. As of August this year, I would have my firm for 5 years, so I'm really excited about that. I'm also a former creative. I used to be a dancer. I trained in the classics, but then specialized in hip hop and African dance. It was great. It was fun. It was the reason I started my law firm. I'm also a commentator. I've had the privilege of being featured on Bloomberg, CBS, The Verge, Marketplace Tech to discuss intellectual property law. I also a speaker. I've spoken at many or several podcast festivals, including the first Afros and Audio Festival last year, as well as Podfest and DC Podfest. I'm a graduate, proud graduate of Duke Law School and NYU. I know basketball season is coming up. I don't know if we're going to actually have one. So if you're a Tar Heel fan, please do not hate me. Also, what's my goal? The mission of my law firm, why I started what I did, is because I want to help all types of people, creatives and entrepreneurs, have that mindset that they're a boss, that they're CEOs. Because when you have that mindset, you're able to move in different ways. And so right now, what I'm going to do is, this is virtual, right? Normally I would ask you this in person, but I would like to find out a little bit more about you. So I'm going to stop sharing my screen. So there are lots of us in this presentation right now. So I'm just going to pick and choose who I want to speak out about and give themselves, like they said, you're going to do this in the chat. You can introduce yourself in the chat, but I would like to know about some people. So I'm going to call your name. I would like you to tell me your name, where you are currently, and what stage of development of your podcast. And if you have a podcast already, what's your name? What's the name of your podcast? So I'm going to probably mispronounce your name wrong. Adjua Greaves first. I would like to, for you to, let me see, I may have to unpin you or like unmute you. Let me see. There we go. Tell me, yep, your name, here we are currently, and what stage of development your podcast is in. Oh, you're mute. Can't hear you. Is it going? Nope. Okay. You can write in the chat. I'm going to go to someone else, but it's all, I love for you to find information. I next see Armand AJ Jennings. And so I'm going to, hi, how's it going?
Good. How are you?
I'm well. Did I pronounce your name correctly?
Armand, yeah.
Where are you currently?
I'm in New York City, just like you.
Dope.
And I'm in early beginnings of my podcast. It's called Play Your Ace.
Nice. What's it about?
It's just about spreading positivity and stuff. I might change the name, honestly, but since it's in the beginning stages, I'm sure it won't be like that much of a problem.
Understood.
But it's about positivity and spreading joy and everything.
And we need that now. So thank you. Okay, I'm going to pick one more person. So let me see. Leslie? Is that cool? Can I talk to you? Can I
yes.
See what's up? Hey.
I was like just playing around. Sorry.
Oh, no worries. Leslie, your name, where you are currently, and the stage development your podcast is in.
Sure. Leslie Faison. I'm calling you from, or dialing in rather, from Northern New Jersey. My podcast is called A Different 50 Podcast. We just finished up our third season with Thank You, which was rough because we, my co-host and I usually recorded in a studio, and because of COVID, we were forced to totally revamp. So third season was rough, but we are looking to, revamp, get re-energized, and all kinds of good stuff.
You got this.
Yeah.
Thank you so much. Everyone else, please enter your name, where you are currently, and what stage development your podcast name, if you have one, in the chat and Hoover. We want to keep as interactive as possible. All right. I'm going to continue the presentation and share my screen again. Okay, we got that. Okay, so this is really important. If you're operating a podcast, you have a business. I know some people may not think that, but you do. And when you do have a podcast, or when you have a business, you have to take steps to protect your business. So what are some of the steps you can take on a holistic level to protect your business? This is it. You want to protect your ABCs. I made a cool acronym. You want to protect your assets, your brand, and your content. So I am going to sort of ask questions throughout this presentation. So I'm going to go to the Hoover chat sometimes, but I'm also going to go back and unshare my screen or to get some of the answers. But for this part, I'm going to look for your answer in the Hoover app. So what tools do you think that an attorney would use to protect your assets? I'm going to look in the chat to see what the answer you provide. What tools do you think an attorney would use to protect a podcast assets? Going to see if we have any answers. I don't see any answers in the Hoover group chat, so I'm just going to tell you the answer. The tools that I would use in my toolbox are entities and contract law. Let me go into that a little bit more. So what are the top common types of business forms that people hear about? You have a sole proprietorship. What is that? That is when someone just starts to have a podcast, right? They just immediately start operating their podcast. no formalities, no paperwork has been submitted. They have an idea. Within a couple of weeks, they start operating their podcast and they're by themselves. A partnership is when two or more people would have a podcast. They just start together to have to operate the podcast, and there's no paperwork involved. Many people I've seen have this type of form. Partnership law is governed by state law, so depending on what state you're located in, different rules would apply. But you don't have to have a formal written down agreement to have a partnership, so long as you take actions to engage in business and take those steps with two or more people, you automatically have a partnership. Now, corporation, LLC, those are two common types of business forms that a lot of people hear about. Corporation, the difference between the two is that one, well, the common thing is that they have to file paperwork to actually form these entities, right? You can't, and unless you file paperwork with the state, you will not have a corporation or LLC. The difference between the two is that one requires more work to basically maintain. A corporation requires you to follow more formalities, they say. You have to have bylaws, you have to have meetings, annual meetings. As compared to the LLC, you don't have to do that. And it's fine, either or. When you have entity, there's more protection of your assets, right? There's a separation between your personal assets and your business assets. So as a lawyer, my job is to think about you being sued, right? That's what I do. I'm a very positive person, but in the end, I have to think about that. So, which is the reason that I usually recommend that if you're concerned about the assets of whether your personal assets, your home, your bank account, you may want to consider having an entity. Now, what type of considerations come into play? I said some of them before, but let's list some of them out right now. Cost, right? How much is it going to cost to run your business form? If it's sole proprietorship, it's nothing, right? There's no paperwork involved whatsoever. Whereas for a corporation, you have to, sometimes pay an attorney to create the paperwork for you. You have to time cost, right? It takes more time to maintain an LLC and a corporation. So you just have to think about ultimately the cost. Again, legal liability. If you're going to be sued, if you're thinking about your assets, you may want to consider having a corporation or LLC. Taxes. I'm not an accountant, but I do have some basic level knowledge about it. There are tax benefits to having certain forms versus others. And ultimately, what are your podcast goals? Do you want to become, do you want to get onto a network? Do you just want to just operate by yourself? You want to think about ultimately your podcast goals when it comes to choosing a business form. Okay, so that's one part of it, entities. The other part is contracts, right? The rule of thumb is this. Anytime there's someone on the other side of you, you want paper. You want to just basically document the relationship to make sure that everyone's on the same page as to how the relationship is going to be governed, right? And so this is a list of some of the contracts that podcasters may consider having. Corporate governance documents, that's like the bylaws for a corporation or a operating agreement for an LLC. A freelance agreement, anytime someone engages work for you, let's say you have someone create a logo for you, or you have someone, I don't know, edit some work for you, like that, they're freelancers. And so you just want to have a type of agreement to make sure that the responsibilities and rights of each party are clear. Music, right? This is huge. A lot of podcasts use music in their episodes or as a theme song. So you just want to make sure that you're clearing, getting permission from both the creators of lyrics and the producing the beat to get to have permission to use that. Music litigation is really, really popular. So you just want to make sure you're not sued. Anytime you have a guest, you may want to consider having a release. NDAs. In case, let's say you come up with an idea for a podcast and you want to actually present it to someone else with the possibility of working with them, maybe you want to consider having an NDA so that they won't steal your idea and start their podcast themselves. And if you will get to this point where you have sponsors, right, coming to you because your podcast is so popular, you have a huge audience, cultivated audience, sponsors will come to you. You want to make sure you have an agreement that's good for you in terms of how much money you're getting, what are your responsibilities, what are in terms of just like obliging with the FTC rules, ad rules, as well as what you're actually going to be doing in terms of the presentation to the audience. Like what exactly, how long is your pitch going to be? Just want to make sure you do that. Okay, Step 2, protect your brand. What tools would an attorney use to protect their client's brand? I would like to see the answers because I don't think I could, I have to stop share to get a verbal answer. But if you could write in the Hoover chat what you think the answer is. What tools would an attorney use to protect the brand? I'm not seeing anything in Hoover.
It looks like copyright and trademark are very popular answers.
Okay, got it. So how come I'm not seeing this? I'm not seeing this. Okay, yes. So trademark is the answer. Trademark law is the answer. Okay, so I'm gonna make this. Let me go and tell you what a trademark is, because I think sometimes people get confused as to what a copyright and trademark is. So a trademark is anything that's used to distinguish one's goods and services from that of another. That's the basic definition. It could be anything. It could be a word, it could be a logo, it could be many things. And so when someone uses your trademark in a way that confuses the audience, confuses the consumer as to the source of the good or service, that's trademark infringement, right? So Nike, like you think about that, right? It has, it's really vigilant about protecting its trademark because it's a popular brand. If it doesn't do that, it's a problem, right? People are going to make money off of their look, right? In a sense, you could think of a trademark as being a source identifier. It identifies the source, the person or the party that creates the good or service. And so we're gonna play a game. Arca, I don't know if people can mute themselves and still look at the screen. I'm not sure if that's possible, but we'll see. So we're gonna play a game called Name That Mark. It's gonna be fun. So I'm gonna show you a mark, a trademark. I want you to tell me what the name of the mark is. Also, I want you to tell me who the owner of the mark is, right? Because it's a source, right? We want to know who the source is. So what is that? Can people mute themselves or do I have to stop share?
McDonald's.
Okay.
McDonald's.
Yes, that is the owner. What is the name of the mark?
Golden Arches.
Golden Arches.
Yes. Golden Arches. I actually saw the movie Founder, The Founder with Michael Keaton. It was pretty good. It's called the Golden Arches. Owner of the mark is a McDonald's Corporation, which is Delaware Corporation. And what is the mark used in association with, right? Restaurants, food, beverages, and toys. Everyone in the world knows what the Golden Arches are, right? It's that powerful. Okay, next up, we have another mark. What's the name of the mark? That's the name. That's the owner. What's the name of the mark?
Swoosh.
Swoosh.
Yes, swoosh logo, owned by Nike Inc. or it's an Oregon corporation. So I think also want to make a good point about this, right? The names of trademarks and company names could be the same, right? Nike Inc. happens to own the trademark Nike too, but it doesn't have to, right? The trademark can be the name of the company, but it does not have to be because it owns the swoosh logo. It owns Just Do It. It owns the slogan. It's just a concept of what you think about. So the swoosh logo is used in association with sneakers, all types of apparel, stores, right? Nike right now doesn't even have Nike, the words on its store. It just has a check mark because everyone in the world knows what it is. Okay, number 3. What's that? Anyone know?
Tiffany's.
Yes. But what is the name of the mark?
Tiffany Blue.
Yes, Tiffany Blue. Yes. And so it's owned by LLC in Delaware, but this just shows you, right? Colors can also be trademarks, but they have to be used on a product. So another one I think that has a color trademark is UPS Brown, like that used on these boxes. That's also trademarked as well. And Tiffany Blue is used on jewelry boxes. Okay. We have one more. Did everyone hear that?
Law and Order.
Law and Order.
Okay. Yes, the Law and Order sound. It's owned by a distribution subsidiary of NBC. It's used in association with entertainment services. The point is that anything can be a trademark. Anything, even smells. I'm pretty sure Downy has its smell trademarked. Anything could be a source identifier. So that's just the point. Okay, so here's a list of some possible trademarks that podcasters may have. Your company name. If you form an LLC or entity, that's going to be a trademark. Your podcast title. This is a major one that many podcasters have. You want to make sure that you choose one that's unique, that can be used for the long term. If you go by a different name, right, like a stage name, that's one as well. Any slogans you have for your podcast, also that. And if you sell a line of products, that can also be a trademark as well. So again, just identifying a source, and that's a trademark. And at the way, at the end, I'm gonna let you ask questions about all this stuff. Okay, so what steps do you take to protect a trademark? First, you have to choose one that's protectable. Trademark law is really complex. There's so many considerations that come into play to make sure that you choose a good trademark, including how strong the mark is, whether the mark is descriptive, whether it describes the location. There are so many different things that come into play. So you just want to make sure that whenever you do actually choose a trademark, that it could be protectable. After that, you conduct something called a clearance search. Even if you pass the first step of choosing a protectable mark, you have to make sure that no one else has used a similar mark in association with similar goods and services. And so you would have someone conduct a clearance search for you where they would do their analysis, and afterwards sort of provide you with the green light, yellow light, red light. Green light, hey, upon my search and my analysis, I think you're good to go. You're able to use this trademark in association with what you want to use in association with. Yellow light, maybe there are some results they get back and say, hey, you want to take a moment to pause and think about this because there could be an issue in terms of protection. And red light, based on analysis, you're going to either be sued or you're going to have to change your brand at some point. So that's just something you want to think about. After, let's say you pass step 1, you pass step 2, afterwards, you register the trademark. This is where you go to the USPTO, the United States Patent and Trademark Office, submit an application, go through the process, and ultimately, hopefully, you'll have a registration at the end. So registration is what you get. You ever seen the R symbol on like marks, like the R and the circle? That's what people use on their marks after they've actually successfully registered the mark. You shouldn't use it before. But that's what something you use. When you have the R symbol, you got registered, you're able to use that mark forever in association with the goods and services you put in your application. And it doesn't stop there. Once you have registration, there's work to do. You have to enforce and maintain the trademark. What does that mean? You have to make sure that no one else tries to use your mark in association with similar goods and services. Again, why Nike has spent billions of dollars on enforcing and going after counterfeiters, because they have to ensure that other counterfeiters are not using and reaping the benefits of their hard work. Maintain the trademark means filing paperwork every couple of years with the USPTO to make sure that saying, hey, USPTO, I'm still using it. Another way is you actually have to enforce, you actually have to police the public. You have to make sure the public knows the difference between your trademark and your company. So good example of this, the term escalator actually used to be a trademark. But the owner of that trademark did not police the public and did let them know that, hey, there's a difference between the term escalator and the term moving staircases. You can't do that. Other types of, when that happens, the mark has become generic, right? Because the entire world uses the trademark in association with the good or service. Another example of that, thermos, aspirin. Those actually used to be trademarks, but they're not anymore because the entire public uses that mark in association with the good or service. Some companies that have actually done a good job policing the mark are Kleenex and Xerox. So that's that. Okay, protect your content. What would you use? What tool would you use to protect your content? You see the chat, you could like unmute yourself and give me the answer.
Contracts.
Contracts, that's one of them. What's the other one?
Lawyer.
Yes. I would say yes, but what type of law would you use to protect?
IP law, intellectual property law.
Cool. Okay, so I'm gonna give the answer. So it is copyright law. So intellectual property law is actually 3 types. There's copyright law, there's trademark law, and patent law. Patent law protects inventions. Trademark law protects brands. Copyright law protects creative works, content. And so you were onto it. I don't know who spoke said that, but you had it. Okay.
Thank you.
You're welcome. So what are the requirements for copyright protection? Right now, it's actually pretty simple. Prior to 1978, there was a whole process that you had to go through to get protection. As of 1978, which we are in right now, it's pretty easy. So long as you have, one, a work of authorship. This includes lyrics to songs, beats to songs, choreographic works, film, like anything creative that's a listed work of authorship that's listed in the Act, Copyright Act, is something that's protectable. Podcast is amongst that. So that's something that's a work of authorship. It has to be original, right? You have to use your own creative juices to create this work of authorship. It has to be original to you. And number 3, the ability to be fixed in a tangible medium of expression. What does that mean? So let's say we talked about this yesterday, actually, during our party, that let's say you created a whole podcast episode and you forgot to press record on your computer. You don't have any proof, right? The tangible medium is your computer, right? Because it helped record your episode. If you recorded your phone is tangible, right? It could be touched, tactile, right? So it just had to have the ability to be fixed with something tangible, right? Because we want proof. When you said you created it, okay, where's the proof? You wrote this song. Did you write it down on paper? Did you type it down on your computer? We wanted to have physical proof that you actually created this work you say you did. So again, requirements for copyright protection. Number 1, has to be a work of authorship. 2, has to be original. And 3, it has to be able to be fixed in a tangible medium of expression. So long as you get that, let me actually skip that. So I'm actually go back to the other slide. But when you get that, when you have the copyright protection, you get what's called a bundle of exclusive rights, right? You get to do whatever you want with the work that you created. You have the right to reproduce it, to put out copies, to perform the work, to create derivative works. Like let's say you have an episode right here, you want to create commercial, you're able to do that. And you have the right to perform it by audio transmission as well, right? You can think of it as bundles. Each right is a separate bundle stick that you can do. And if someone wants to use your to actually exercise that right, they have to get permission. So I'm gonna go back to some of the copyright owners in a podcast. You have the podcast hosts, right? They're the ones who are, creating questions, probably talking. This is important too. Your guests also are creating copyrightable material, right? They're giving their own original answers to your questions that they ask. So they are the copyright owners in what they create. Creators of music. Music, again, is very important to podcasts. And so you make sure that's something you think about. Any artwork, right? You have a cover or a logo or something of that sort. Those are some of the copyright owners that are involved in the podcast industry, right? Bundles of sticks. So again, what if someone wants to exercises this bundle with the stick, one of the sticks without permission? They've engaged what's called copyright infringement, right? They infringe upon your right to do your exclusive right to do whatever you want with that work, right? And so again, they have to get the permission. So I wanted to talk about the doctrine of fair use. This is something that I think people hear about and sometimes get confused about. I've seen sometimes people wrote on YouTube videos like fair use intended, or like, this is not my copyright. This is not what I own. I don't own this, right? So it doesn't necessarily protect you. So long as you engage in copyright infringement, let's say you reproduce someone's work without permission, you'd engage in copyright infringement. Fair use is a defense to copyright infringement, right? And so you have to think of it like that. What is it exactly? So you have this exclusive right to do whatever you want, but the government, or the founders of the founding fathers, because this is in the Constitution, Copyright Act, copyright rules, it's in the Constitution. They want to have a limited use, right? This limited use of how much you copyright, because there will be no creativity if it was stifled to that extent. So fair use is actually a doctrine that's created by the judges after that. And so it limits the copyright intended to balance the interests of copyright holders, right? Because we want creative juices to flow. And so the key is, again, that it's a defense in copyright infringement. So if you're using it, that means you're being sued. You've been served a subpoena, you've been going to court, and you're going to defend yourself saying fair use. So you can't preemptively say fair use, I did it. No, you be in court using this defense. Sometimes what people have me do is they do a fair use analysis saying, hey, if this happens, if I do X, Y, Z, what will happen? Will I be sued? Is it fair use? And so that's another way I can think about it as well. So if you have fair use, you just write the words fair use, that doesn't work. You can either be sued and then use a fair use defense, or have an attorney provide you with a fair use letter, and we do research and give you our opinion as to whether your actions would constitute fair use. Okay, so what steps do you take to protect your podcast content? You can secure licenses for music used in your podcast. You can execute agreements to secure IP from other creators, your guests, right? That's something you could do. You can either have it assigned to you right out or licensed to you. They're giving you the right to, they still own it, right? They still have ownership of the copyright content, but they're giving you a license to do whatever what you want with it without permission, because you got permission. That's when you hear the term license, it's basically asking permission to do something. Also, too, this is important. You want to register your podcast episodes with the Copyright Office within 3 months of making it public. Okay, why is that? So again, if ever you'd be sued, I don't actually engage litigation, but this is something to think about. So long as you make your episodes public within 3 months, if ever you were to sue someone else for copyright infringement and you were to win, you'd automatically get damages that are listed in the statute. I think the highest end is $150,000. So for each instance of infringement, you automatically get damages. Normally you have to prove damages, but the Copyright Act said, nah, it's okay. So long as you prove that you had someone infringe upon your rights, you could ask for statutory damages. But that only happens if you register your podcast within 3 months, making it public. Now, don't worry, if your episodes have been in public for more than 3 months, you can still register it. You just won't be able to get the statutory damages. This is important to note. Because of a Supreme Court case last year, you cannot even sue for copyright infringement unless you have registration in hand. You can't do that. So it's a little bit easy process. You just go to the Copyright Office website and just do the process and register your work. So again, the best way to do this is to register your works within 3 months, making it public. But if you don't, you just want to register them anyway. All right, questions. I'm going to go back to that, but there's my information first, because I want to do questions. I want to see your face and I want you to ask me that. So here's my information. In my website, on my website, I have a free checklist, a business checklist that you can have as well. And I have a blog that has a whole bunch of information about all the stuff I talked about: copyright, trademark, contracts. So you should definitely go there. All right, questions. I'm going to stop share. So
we do have 3 questions for you in the queue, Merlin.
Okay. What are they?
The first of which
I have to give caveat. Okay, you cannot ask me about personal advice. I cannot give you personal advice. I'm held to ethical standards as an attorney. I cannot give personal advice in public. It would have to be private. So if you want to ask me a question, make it as general as possible. Because if I think it's going to be personal advice, I'm gonna have to say I can't answer that.
Understood.
Yes.
Now, the first question is, are there minimum documents that podcasters should have if funds are in fact limited?
I'm going to give you the worst answer as a lawyer. It depends. It all depends on your risk liability. Like how open are you to risk? If you're not, then it doesn't really matter. But I can't answer that question. It depends on the risk liability. If you're worried about being sued, if you're worried about your content being stolen, if you're worried about those things, that's what comes into play. Google is your friend. You can Google lots of things. And try to you can find templates and try your best to, make them adjustable to yours. But I gave you a list of some things that you can list that you could find. If you want to find them and try to modify them, go for it.
Thank you for that great question, Lisa.
Thanks, Lisa.
TT also has a question. What steps should a person take to enforce or protect your trademark prior to contacting you or another attorney?
That's a good question. I don't know. The thing is that the contract, because trademark law is so complex, I think about that. If I was to answer that question, maybe a Google search. I mean, Google is not the best though. A Google search, do a search in the USPTO database, but it's not the same mark, right? When it comes to trademark analysis, it's not finding the same mark, it's finding a similar mark. And that analysis is a little bit different. And other considerations come into play. But TT, that's an excellent question. I would say Google, because most of the things of determining whether a mark is protectable, I don't know if someone who's not an attorney could know that.
Okay.
Yeah. You can also on my blog. I have lots of articles about trademarks. So go and dive, swim, do all that stuff in my blog.
And can folks get to your blog from your website?
Mm-hmm.
Excellent. Okay. Yeah. And the next question is from Charity Gates. Mm-hmm. Do you recommend filing a copyright application for each episode or script of the podcast?
That's a good question. Both are copyrightable, right? Both are copyrightable. The episode itself, recorded, is one version, as well as the script itself is something different as well. Yeah, so like that's why I say every 3 months. So I would say it could be cumbersome after every single episode. If you're doing a weekly episode or even a daily episode, it could be very cumbersome going to the USPTO every day or every time you do that to register it. Which is why I say do it every 3 months. So let's say it's January to March, right? Maybe in March you could register the works that were everything you did in January and February all at once, and then continue that process throughout the year.
Got it. Another question from AJ, trying to be as general as possible. What are some of the very prevalent issues or most common issues that you typically see with podcasts and their brands?
Let me see. Choosing a name of a podcast that is descriptive. So that's a bigger one, right? Remember I talked about the strength of a trademark? You don't want to choose a mark that's descriptive of the content within your podcast, because it may not be ultimately be able to be registered. I mean, descriptive marks can be registered, but they're ultimately more difficult. But you just want to not choose a mark that describes with the content of your podcast. That's the mistake I see a lot. Otherwise, you're gonna have to wait a long time to get registration. So that's common, I see. That makes sense? That make any sense to anyone? If that doesn't make any sense, let me know. Because in my head it does. I don't know.
I didn't get that.
Can you elaborate? Yeah,
sure.
Can you elaborate?
Okay,
I'm sorry.
So if you go, there's a spectrum, what's called a spectrum of distinctiveness. I should blog post about this. So the least distinctive your mark is, you won't be able to get past that muster of going to register your mark. On the lowest end, you have marks that are generic. These are marks that describe, basically describe that tell you what the good is. If I wanted to sell oranges and name my company Orange, that's not gonna fly, because the entire world calls like orange and orange. Descriptive marks. These are marks that describe a trait or characteristic of a good or a service. Good example of this is Travel Centers of America. You're a travel center and you're in the US or Canada, right? That's the descriptive marks. USPTO does not like that. It doesn't bar you from being from getting registered, unlike generic marks. But there's a higher bar, right? You have to get something called acquired distinctiveness. That means 5 years of use, continued use. So you have to wait a long time to get a descriptive mark registered on the principal register to get protected. So that's how I'm saying that you don't want to choose that type of mark. That make sense?
That's clearer.
Okay, cool.
Thank you.
Please let me know, because in my head I'm like, I talk about it all the time, so it makes sense to me. But I just need to make sure that I'm saying it in a way that is understandable to all. Any other questions?
Yeah, we have about 17 minutes left, and I can't stress enough that this woman is a wealth of knowledge. Please chime in with your questions directly if you'd like.
Yep. I talk really fast. This is why you have so much time left. That's it.
It was amazing. I could tell that's what you were doing.
No, but I just talk this fast. That's how I roll. That's what I do.
It's great. I have a general question, and I do believe it's about fair use. For like in this time when we're transitioning more towards online content and virtual content, I'm noticing that different people at different levels of professionalism are reading the work are doing audio performances of other people's writing. And I'm always curious about the fair use of that, like where the line is. Yeah, you understand.
Yes, I do. So you don't know what's happening in the back end. You don't know whether that party has gotten permission, a license contract, to get permission to do that. So that's number one, right? So I remember when Beyonce, who is queen, who's awesome, amazing, right? When she used some content for formation from these creators, right? The creators gave they basically gave their rights to a production company. You know, Beyonce is about securing her, you know, she's about crossing her T's and dotting her I's. She got a license from the owners of that work to use it in formation. But yet those creators who actually created it said they stole it from her. I'm like, no, she secured the rights that she had to. And so you don't know, I guess say you don't know what's happening in the back end, number one. After that, I don't know. Like social media is so interesting, right? So everyone's engaging in infringement. If you repost someone's video on Instagram or like TikTok, or like you're technically engaging in copyright infringement. That's the thing with the law. The law is old, right? This law was created in 1978, before internet, before social media, and so it's gonna take some time to catch up. You know, we're gonna try to mold this law and apply it to what's happening now, but it's hard, right? So technically, every time you do that, you're engaging in infringement. How likely is it someone's going to sue you? It's also a question is it worth it, right? Am I going to sue someone for reposting this when I can get all this bad press, lose my business? Is it worth it too? So that's a question you have to ask. Like sometimes it's not always about the law. Sometimes it makes sense to think about your brand as well and business too, right? As I said, you're a business. You got to think about that too.
So we've got some additional questions. First is, should you find an attorney in your state, or does it matter if they are out of state?
It depends. Yeah, certain states are a little bit weird. So like I'd say like it doesn't necessarily. I think you want to find someone who's experienced in the areas that you're working in. Someone, let's say you're in, I don't know, I'm just a random state, Texas, right? You can find a Texas lawyer, but you just want to make sure that they're experienced in the area that you're talking about. They're podcasting, make sure they're in podcasting. It doesn't necessarily always, for copyright and trademark, it doesn't matter. That's a federal law. Your lawyer could be anywhere in the world. It doesn't matter. But when it comes to do a contract, you may want to have someone who's barred in the state under which the contract law will be governed by, right? But you could be in Texas, right? But you could have your contract governed by New York law, by California law. You could be whatever. It doesn't have to be the state that you're living in. These are some excellent questions I'll ask him. Thank you.
Thank you for that question, Blake. The next is, what if you find another podcast? I'm sorry. What if you find that another podcast has the same name as yours? Yeah. What steps should podcasters take if they see that happen?
Number one, see if it's registered, if the trademark is registered, if the other side has the trademark registered. I've seen some people say like, I'm gonna go talk to them. Like, no, don't do that. You don't have, if you're really attached to that name and you want to make sure you want to use it, you want to go through the steps I told you. Do a search first. Do the clearance search. Do the registration. That's what you want to do. And then if that happens, you actually get registration. You're gonna have to go to the other party and say stop using it. That's something you want to do. That's something that's worth it, or is it worth to just rebrand? You know, you can either take the steps to register, or you could just maybe want to rebrand, depending on whose rights are superior. They started using it before you. You don't have rights. They started using it before you.
And another excellent question from Latrice. Do you need permission to use content from public forums like Reddit or Medium in your show, like discussing a post made on Reddit or doing an opinion piece on an article that you found on Medium?
That's okay. So the fair use factors, what are they off the top of my head? Fair use is so intense because it depends on how much work is taken, how the quantity, the type of work, what you're doing with it. Like, it is just so particular that I cannot answer that question. It depends, and that I know that sucks, but just because something's in public doesn't mean it's not copyrightable. Doesn't mean that it's still a work or authorship that is that is original and fixing something tangible. It's still copyrighted. You still have to follow the rules and try to figure out what happens. But like you said, fair use, and one of the concepts is like, if I do a news report, can I actually not get permission from them? Like, you totally can, you could try, but you may be sued. Like, and just just because if you do a fair use analysis and say you're good to go, doesn't mean someone won't sue you. People love to sue. This is America. People just love to sue people. So it just all depends on your risk level. Thanks, Latrice. Did that answer your question, Latrice?
I think Latrice had to step away to prep for another session, but I hope so.
Okay. Any other questions?
We've got about 10 minutes left.
Okay, I see the chats now. Okay, now I'm able to see the chat.
Excellent.
In Zoom. Is it also in? Yeah. Any other questions?
I have a question.
Sure, Leslie.
I had typed it in the site. It's kind of a two-part question.
Mhm.
First, those sites where you can download music and pay for it and use it, how legit are those? Say, for instance, if you wanted to use that as your new theme music,
Yeah.
knowing that someone else could potentially download the same song as well and use it as well. Could it pop up from that?
So it depends. Most of those sites have terms of use. As to what happens to the work when you use it. Like they would say, hey, these are terms of use. If you use this, if you purchase this license, you're able to do X, Y, Z with the work, right? So that person is still the owner of the copyright is still gonna own the copyright, right? But this is where license comes into play. License is permission for someone else to do the work. So I guess example of this, the Read I listened to, they used a portion from, what song did they use? Oh, Happy Day. But I think, isn't that from Sister Act? I think they use it.
Yes.
And so like, I'm going to assume that they, they secured some rights to that, to use that. And so they got licensed, right? They got permission from the owner of the copyright to use that. So there's not a problem. If someone else is using that copyrighted work, and it has a different podcast, I don't think there's a problem because the owner of the copyright is not the other podcast owner, right? They're also getting a license as well.
Okay. And then yes, it does. And then the second part of my question is, if you had someone create a drop or like a theme for you, you've paid them and everything, paid them outright and all that. What happens? Is there any way that they could ever come back to you and say, you're using my content?
This happens a lot too. So where like you pay someone to create, either like a logo or do some work for you, and you just pay them. There's no contract whatsoever. Rule of thumb is this: the only way to transfer copyright right is in writing. There's no other way. It's like you can think of property, intellectual property, particularly copyright, as being like you have real property, right? You have a deed, you have to trace who owns it, you got to go do a title search. The same concept applies to intellectual property. You got to do a title search as to who owns the copyright to that work. And so who owns copyright to that work if there's no agreement, even though you paid them? Who owns it?
Yeah, they do.
Yep, exactly. So you got to go back and get the right. And I've been in situations where after, you've been using it for years, you do all the work to make that, that work valuable. And then that other party wants to ask for a lot of money because of that. So it's always better to just do it early in the process. Always.
Gotcha.
And so the best thing to do is to do it preemptively. Whenever you're having someone engage the work, when you want to engage someone to do work for you, have all of that in one contract. I'm giving you the money, not just for the actual physical thing, but also for the rights, right? You think about Andy Warhol, right? The state has the ownership of the copyright to all his works, right? Probably everyone in the world has a copy of Andy Warhol print, right? We own that physical copy, right? That reproduction, right? But who has the right to reproduce it? The estate does, and that's the more valuable right.
Got it. That's scary, but thank you.
I'm sorry. I'm keeping it real. I've seen stuff. I've seen things.
So I feel like we touched on this a little bit already, but we have a question from a late entry to the session. They don't know if it was already addressed explicitly, but their question is, what are the rules for the use of music for review?
Use for review. I'm not sure what that means.
Please feel free to jump in and expound upon your question. Scorpion, I apologize if I said that incorrectly. Yeah.
And just a caveat, I don't really work in music. I have like the basic knowledge about music, but I don't really know like music law and whatnot, like the particulars about getting production. So these terms, I don't know what you mean.
Okay, Scorpion here. Can you hear me?
Hi. Hey, Scorpion.
Okay, I was asking like for a review, like if you're breaking down the lyrics of a song or what have you, or you're just talking about the feel of the music and how it makes you feel and going in those types of areas. What are the rules for that?
I'm gonna say this out my purpose outside of what I know.
Okay.
Yep.
Thank you.
No problem. I have a good friend, Nia Rasul. I'm gonna put her name in the chat. If you want to ask particularly about music questions and like in depth and things like that, you could definitely hit her up. So Nia Rasul. Oops, hold on 1 second. Music lawyer. Any other questions?
Hi, Marlene. I have a question.
Charity.
Thank you for doing this chat, by the way. I really appreciate it. But I was wondering, what should you format the podcast guest release form as? Should it be like a
Depends.
full on like a letter agreement, or
Depends.
should it be a big
Depends.
contract?
Depends.
Okay.
And that's the thing with contracts. I mean, there's just like you have like templates, but like every single thing, every single section of it is gonna. It's like it's an art to create the perfect contract, because you have templates, but you gotta talk to someone to see exactly what they want and to see what the other side wants too, to come to a certain agreement, right? The perfect relationship in terms of dating, right? Romantically, sort of the same concept applies contractually in business. Is it gonna work? Is this contract going to make us comfortable getting into a relationship together? Because that's essentially what it is when you're actually entering into a contract. Are we comfortable? If not, then you have to bounce out. Swipe left, press the X button, keep it out.
Thank you.
You're welcome.
Hey, I had a question.
Hey, Sean.
Hey, how are you?
Good, how are you?
Good. So one of the questions I had, and I've seen this conversation come up, like what are some of the legal implications to think about if you consider repurposing episode content for something later, like a book or anything like that? Is there things that you should probably think about as you're moving forward, or if you've gotten a release for the content of the episodes, you would be good to go with later repurposing in that way?
So this is why. So let's say you have a guest in your episode, right? If you were to get all the rights, so like, or like get permission to do whatever you want with that, like it would help, right? Because if you want to repurpose your content and you're using someone else's voice or their material, there's a problem if you don't have permission, you know. So I would just say preemptively just get permission if someone else is involved in your not only just your as a guest, but if they're as an editor. They're also engaging in creative process as well. So you just want to make sure that you have those types of rights preemptively just gotten before you do something like that, because it can open you up to liability to be sued.
Gotcha. Thank you.
So Marlene, this is Talib.
Hey, Talib.
Hey, so to expound on Sean's question, would it be as simple as putting in the contract that it's possible that it could be repurposed for this, that, and the third? Any vision that you have, throw it in there.
I'm gonna say no, because I can't tell you. Like, I'm gonna say no because it has to have particular language. It can't be just one line that's gonna cover you. It has to be particular language that's going to make sure that's covered.
Okay.
Yeah.
Thank you.
And speaking of coverage, Merlin, Ann Smith is asking, what is the best way for a freelancer to protect their IP work after project completion?
Can you give me a little more context, Anna?
Ann Smith?
Yeah, can you give me more context?
Hello?
Can you give me a little more context as to what we're talking about?
Hello, can you hear me?
Yes.
Yes.
Okay. So like sometimes you'll have like a freelancer do like maybe like a blog post for you, or like just freelance work for like maybe like a music clip or a drop clip or something. And I know sometimes people will have they'll have I know sometimes they'll take like the IP work of that person, but then that person may want to still hold. Is there a way for that person to still protect their intellectual property after the project?
So this is a contract, right? So this is this comes to place when when you first engage. So there are two ways to get, when it comes to rights of copyright in particular, you could assign. Does anyone know what assign means? Does everyone know what that means or not? Assign means you're giving all the rights to the other party. Like, I created this IP, but I don't own anymore. I'm giving you ownership of all of that. A license means I still own the rights to the copyright, but I'm giving you a license that has particular language to say you can do X, Y, Z with this work. That's okay. That way, the freelancer, if they want to still have ownership of their rights of what they own, then they'll be fine. But again, if the freelancer doesn't have a contract at all with the other party, then who still owns the IP? The freelancer does. Right. There's no issue.
Yeah. These are great questions.
These are excellent questions.
We have about 1 minute left. Yeah. Before we wrap up, can you please tell us where we can find you again? Yes. Thank you.
Sure. So you can find me on the interwebs. I have a very unique name. So if you Google me, you will find me, Merlin Jean-Louis. You can find on my website, jllaw.net. I am on Instagram, Wizard Lawyer, as well as Jean-Louis Law. And yeah, you find me. I'm there.
Thank you so much. This was amazing.
My pleasure. Thank you everyone for participating, for answering my questions, for asking amazing questions as well, because my mind was like doing mental gymnastics. So appreciate that. Okay.
Thank you.
My pleasure.
Thank you very much. This was amazing.
Take care. Thank you.
Yeah, this was super valuable info. Thank you.
My pleasure.